All right, good morning, everyone. Today we are going to talk about bankruptcy, and we're going to go over sort of a general overview of it. Bankruptcy can be a little involved and in-depth. This is really sort of what we need to know in terms of getting that real estate transaction closed through the bankruptcy process. Also, if you ever are thinking of filing bankruptcy or have friends that are filing bankruptcy, here's just a little bit of information on it. We're not going to go too in depth, like I said, much more of a general overview. Feel free to ask me whatever questions you want to ask. I worked in bankruptcy and foreclosure for a number of years, actually at the height of the foreclosure back in 2008 and 2009. So this is, I wouldn't say a near and dear topic, but I do know a little bit about it to be dangerous, I guess. So what is bankruptcy? It's a federal court procedure that helps individuals or businesses liquidate or reorganize their debt. So bankruptcy does fall within the federal guidelines, but each state is going to have a little different rules. So federal court you go to federal court for bankruptcy, but then you have specific state statutes on some of these things, and we're going to get to some of Florida statutes in particular. So once you file bankruptcy, it prevents continued efforts by creditors to collect debts. It puts a stop to that. So that's why a lot of people, you'll see they have a ton of debt. These creditors can no longer contact them as soon as you file bankruptcy. One of the things bankruptcy is not, it is not a get out of jail free card. You still, for the most part, have to repay things. Back in 2005, there was, or 2007, I should say, there was bankruptcy reform that was done because people were using bankruptcy as a way to pay off credit card debt. They'd rack up a bunch of debt, pay it off through bankruptcy, and go about their merry way and, rack up more credit card debt, file another bankruptcy. And now the bankruptcy courts are like, no, you have a certain amount of time before you can file again. And it's really about getting you back on track, getting your finances in order. It only relieves the debtor from personal liability for dischargeable debts. And then you need a court order to release a lien or mortgage, so which we're going to get into. So just because there's personal debt, it doesn't necessarily mean it releases things like mortgages and judgment liens. And that's where it gets tricky for us in the real estate industry. So just have an idea of bankruptcy. It's a federal court procedure. There's Florida rules of law that we have to follow as well. And all it does is it prevents creditors from continuing efforts to collect that debt. It puts a stay on it. So general rules of bankruptcy. And like I said, general rules. There are obviously certain situations where certain other rules may apply, but these are the basic rules of bankruptcy. When you file for bankruptcy, and you will see BK throughout the presentation, BK just means bankruptcy. When you file for bankruptcy, you are no longer in control of your assets. The bankruptcy estate, the bankruptcy trustee, now controls all of your assets. You give up that right when you file for bankruptcy. Certain property is exempt from bankruptcy, and we're going to talk about that, things like homestead. Only unsecured debts are discharged. Unsecured debts are your credit card debts, things where there's nothing with a collateral. So when you take a car loan, the collateral is the car. When you get a mortgage, the collateral is your house. That's secured debt. Secured debts aren't typically discharged, which means just because you file bankruptcy doesn't mean you stop paying your mortgage or paying for your car payment. Some debts can't be discharged at all, and those are typically those debts that have to do with like child support and things like that, alimony, those family court kind of rules. One of the key things, and this comes down to us for real estate, is you must wait at least 14 days to act on any bankruptcy order. And that's where we see a lot of arguments come up with bankruptcy attorneys, or you as a realtor might say, well, we have an order. We still have to wait 14 days because the 14 days is going to be the appeals for that whatever order is given. So just note that if we get a bankruptcy order, there's an automatic 14 days we're going to have to wait. So these are the general rules. Now we're going to talk specifically about some of the bankruptcies. There's a bunch of different ones, but these are the big ones that we're going to see. Chapter 7's liquidation, Chapter 11's reorganization, and then Chapter 13 is adjustment of debts of an individual with regular income. There's Chapter 12, which is for farmland. There's Chapter 9, I believe, is for municipalities that file for bankruptcy. So we're not going to concern ourselves with these. We're just going to talk about these types of bankruptcy. We're also just going to talk about real property. So what happens to your car, it's not going to be covered in here. You know, what happens with student loans, not covered in here. We're just talking about the real property, because what happens if you take a listing and you find out the seller is in bankruptcy? This is what we need to know. So Chapter 7 briefly is liquidation. What does it mean? It's a way to for individual debtors to eliminate their unsecured debt. Once again, unsecured, no collateral, credit cards, etc. So they want to get rid of that debt. They've racked up, you know, a lot of fees, a lot of credit card debt, whatever it is. This is a way to get rid of it. It's overseen by the bankruptcy trustee. So you file Chapter 7, your assets go into the bankruptcy estate. Bankruptcy trustee controls everything. You no longer can touch it. Bankruptcy trustee will sell any non-exempt property and distribute the proceeds to creditors. So in the real world, if you have 2 homes, one's not homestead, that second home's going to be sold to pay off the debt. Not everyone is eligible though, and every state has maximum income levels, and you have to meet these requirements. For Florida, we have these median income levels. So from May 1st to the present, this is the monthly income and the annual income levels you have to be under in order to file for Chapter 7 bankruptcy based on the household size. So if it's a one person, your monthly income has to be less than $4,296.58. Your annual income is less than $51,559. Now, if you make more than that, there is a means test, which all you have to do is prove that with all the debt you're paying off, this is, you know, you're making basically this annual income and this monthly income. But that's going to be a means test through the bankruptcy court to prove that you can file for Chapter 7. If you can't file for Chapter 7, you can always file for Chapter 13. But this is one of the back in 2007 when they redid the bankruptcy rules, this is one of the things, because you had a lot of wealthy people filing for bankruptcy, and it's like, no, you can pay your debt. So we want to keep it to people who are really in need and trying to weed out some of the people that were taking advantage of it. So this is just the means test. It changes maybe every year or so, but for this year, for 2020, this is what we've got. Chapter 11, reorganization. This can be used for individuals or businesses, and you'll see Chapter 11 obviously popped up. Just who's filing for? J. Crew filed for Chapter 11. I think Nordstrom's did. So you've got a bunch of different Pier 1. So a lot of businesses use this because they have gotten themselves into debt and they need to reorganize. It doesn't necessarily liquidate all the debt, but it can at least reorganize how they are spending their money. So generally a party who's in the business of selling real property, such as a business or a builder or developer, can continue to sell the property as long as it's within the scope of what they do. So that's kind of the nice thing if you're dealing with a business or individual that has filed Chapter 11 reorganization, they can still go ahead and buy and sell properties. It has to be within the scope of what the bankruptcy court's going to allow. And they will definitely set parameters on what is the ordinary course of business for that person or that business. So these are the things when we're working on the title and we're looking at what the bankruptcy court is allowing us to do or not do. So just because there's a Chapter 11 bankruptcy does not mean that your debtor, your person, can't buy and sell property. Chapter 13, this is the adjustment of debts of an individual with regular income. So this is only for individual wage earners. They have to have a regular income with a steady job. So contractors are typically out on this. You know, a salaried employee or a full-time hourly employee will be able to use this. It's also used when you make too much money on a Chapter 7. So you had that median test, you don't meet that means test, that you can't prove that all that debt has now caused you to lower your monthly income. You're going to use a Chapter 13. And the trick with the Chapter 13 is it's a plan. It's a plan on how you're going to repay that debt. It's usually 3 to 5 years. The bankruptcy court's going to help you with that and make that determination. And, you know, so debt's not being wiped off or liquidated in a Chapter 13. You are going to have to repay that debt. That's why, you know, you have to meet that means test, because a lot of people have lost their job. And so they're definitely going to meet that means test. But if you have a regular income, you can't use the Chapter 7 just to get rid of your credit card debt. They're going to make you repay it. And this one, you're going to keep everything you own. And you'll have to pay the value of the non-exempt property or your disposable income, whichever is more. So Chapter 7, all your stuff gets taken over by the bankruptcy trustee. The filing of the bankruptcies. So a bankruptcy can be filed voluntarily through a bankruptcy petition. So you go in and you say, you know, I've gotten myself in way too much debt. My only way out right now is bankruptcy. Or sometimes creditors can force you to involuntary bankruptcy. We see that with like the Chapter 11s, where the investors in companies are like, God, these guys are blowing through this money. We need you to reorganize. So you are going to file a Chapter 11. Typically, Chapter 7, Chapter 13, they're voluntary bankruptcies. So what we look at when we have a bankruptcy in our real estate transaction, we want to look at the docket. The docket's going to tell us what's happening, where we are, what we can and cannot do, what the bankruptcy trustee can and cannot do, what the debtor can and cannot do. So the first thing you do when you file a bankruptcy is you file a petition, and you're going to file some schedules with that petition. And we're going to review some of those. Then within about 30 days, you have a meeting of creditors. It's called a 341 meeting. That's just the statutory terminology for it. So meeting of creditors is where this is the only time the debtor actually goes to court and talks about, you know, why they're in debt and why they can't pay the creditors. Then you have notice to interested parties of any orders relied upon. So with the whole bankruptcy process, there's a lot of notice you have to give to creditors, to other interested parties, such as tenants in common, things like that. And we have certain things like order authorizing sale, approving plan, abandoning property, the 522F, and the lifting of the stay. And we're going to talk about all those. Then, like I said, we have that notice of appeal, that 14 days after any order. And that's where right off the bat, you guys have an order, or your seller has an order, you know, authorizing whatever. We still have to wait 14 days before we can even close on it, because we have to wait for the appeal process. And then there's discharge of the debtor. So these are the items we're looking for in the bankruptcy docket. Where are we? What are we doing? What can we do with the property? So one of the things with bankruptcy, like I said in the beginning, as soon as you file bankruptcy, it stops all creditors from trying to collect on their debt. It is immediate as soon as that bankruptcy petition is filed. What it does is it stays most collection actions against the debtor and debtor's property, including foreclosure suits. FC is for foreclosure. So it's an automatic stay, automatically stays any debt collection from any other party, even mortgages. So if you have a mortgage and the mortgage company is putting you through foreclosure, that foreclosure action is completely stopped. They can't go forward with the foreclosure. Stay may be terminated by an order lifting the stay, which sometimes I worked in foreclosure, and if there was reason enough for the foreclosure action to continue, the bankruptcy court will lift the stay, and the foreclosure action can run simultaneous with the bankruptcy transaction, depending on what the property is and whatever it is. So we're always looking for the lifting of the stay, because that's going to make a determination on what we can do with the property as well. There are prohibited creditor actions, so no continuing judicial, administrative, or legal proceedings like foreclosures. You can't enforce judgments, creating or perfecting or enforcing any liens, and no set offer of debt. So with this, you basically, everything's stopped. No one can proceed with any additional action. But what it doesn't affect are that paternity, alimony, child support, dissolution of marriage, domestic violence, anything that has to do with like the family court, as like to call it, does not get affected by the state, does not get affected by the bankruptcy. You still have to pay child support and alimony. That doesn't stop because you decided to file bankruptcy.